Hello, everyone. Happy to see you on this webinar. We have 27 people already. Great start. Today we, as usual, talking about the MiCA regulation and the most hot topic right now, how to apply or how to avoid applying. What the so MiCA isn't the only way or not. And today we have our guest. It's Nikita Prokopenko. He's lawyer on SBSB. And Nikita, please introduce yourself. We are happy to have you here.
Hello, everyone. It is a pleasure to have you, everyone, here today. Today there will be a very nice presentation, very useful for you, for people who doesn't want to go with MiCA but still want to work with the European markets. I'm a lawyer. I work at SBSB FinTech Lawyers. We've been doing it for more than 12 years. We work on fintech, crypto, gambling. And yeah, I think it will be very useful for people who still are looking for some options which to enter or continue working on the European markets, but understand that the regulation is quite tough. And with that regard, I will give you some insights, I'll make it more clear, and I also hope to answer your questions in the end.
Okay, thank you, Nikita. And from myself, I want to introduce, my name is Vadym Rozov. I'm host of these webinars. I also am CEO of Simplify Labs. We are a software development company. We are providing white label solution and on-premise solution for the MiCA regulated and also not MiCA regulated companies. And I am happy to host this event. And want to start with small chit chat with our guests. People who joined us. Can you type in the chat section what country you are working in, and do you have currently WASP or just looking for this opportunity? We'll be happy to see. Okay.
I hear some people working from France, Poland.
Okay, Poland. Cool. Lithuania, Malta. Great. We have a really good friends from Malta. Slovakia, UK. Latvia. So we have presence from all around Europe and even UK. And I believe the current agenda will be interesting for everybody from this group. And also, Nikita, I want to discuss with you the current situation of issuance of MiCA licenses. What do you think about the progress regulators all around the Europe done so far? And is it enough licenses issued at this moment, or not as you expected from this point of view?
So the MiCA is quite difficult regulation to implement for all of the countries in the European Union. It was not only difficult for countries who already been working with crypto, like Poland, or Czech Republic, or Lithuania. They already had some laws in place, or they already had some regulation that needed to be more strict, more higher standards to be implemented on the control for the directors or shareholders or the share capital and so on and so forth. It is also was difficult for countries which were not ready for crypto yet, like Sweden or like some other Western European countries, more traditional markets. They were also experienced some difficulties with implementing MiCA, but more or less the transitional period solved this problem. At this point of time, we know that not many MiCAs have been have been issued. Last week, I believe I've been in Malta. We discussed the situation with the regulator. They issued 4 crypto licenses for Crypto.com, for Bitpanda, you know that for the some local operator as well. Yeah, and for that reason, this is and also sometime in Germany, but it's not that huge. There are no many applicants. in place as for now, because of the transitional period, but also because of the complexity which MiCA implements on the current state of things. I believe MiCA is one of the most complex license that you can get in the world. There are some exceptions, like Hong Kong or United Emirates, but as for now, European license is one of the most difficult that you can get to operate in crypto.
No, I just want to add, just today I downloaded the list of issued licenses in Europe, and I see that currently this is only 27 of them, and the biggest amount in Denmark, it's 10 licenses, and on the second, this is 8 licenses in Netherlands. So in Malta, I see currently it's 5 licenses. It's also Bitpanda, Crypto.com, Altarius, ZBX, and OKX. So this is
Correct,
5.
yeah.
And in general, like you can agree or disagree with me that regulator issued licenses only for the biggest players on the market field. I don't see the no names or like only top 10 or something like that in the world. And after that, they just stopped issuing these licenses and put on hold for, I don't know, for 1 quarter already, like 3-4 months. And do you have some information regarding this is like temporarily or this just waiting for some additional instruction for them how to issue more licenses or something like that?
Yeah, so the situation was unclear for the reason that there were ESMA and EBA guidelines as how to implement their MiCA regulation. And well, at some point, you have to report which licenses have you granted and how careful you were. The government has to report to the European regulators how well is the implementation is going, and who get the licenses. And the situation happened the same thing, let's say, as in Malta, that first they granted many licenses, then the ESMA came to the regulator and find there were huge violations of rules by OKX for the KYC procedures and some others which were not in compliance with the newest guidelines as issued by ESMA. So now ESMA is doing sort of due diligence over the local regulator. That's why it stopped here. Similar or maybe or almost similar situation happens in the other countries. So when it's at first it was launched for the biggest crypto service providers who were preparing for months before the launch of the new regulation. They were ready. They did have many conversations with the regulator. They were in place. They did pre-submit their documents in sort of way to get sort of informal approval from the regulators, as happened in many countries, in the Netherlands as well. But then for people who are trying to apply now, as the applications are open, it will take 4 months, 3 months to get the approval, which is not that bad, because you know that the transitional period extends your license till the license is granted. So you'd be able to operate this time in most of the countries. But if you want to start from scratch, you would face some significant delays in that sense as well.
This is the next question to you. Yeah, so you want to start new business. You can't open right now new WASP. You should wait for CASP at least like 6-9 months. Nobody can tell you exactly what the process will be and what the legal workaround, what the alternatives. Can you present this information to us?
So if this is a great question, and this is actually why we're here. The point is that you will still know the way how to work with the European market, right? And you have lots of customers. It's a huge market. 400 million people, like 450 million people is currently at the market. They, to a certain extent, want to receive crypto services, right? But then there is a new MiCA regulation, which is very strict, and in that sense, they did their best to exclude almost any non-authorized services on the European market at the moment. However, there are some exceptions, and of course, you can. What is the structure of the presentation will be that first I'm going to tell how it is possible to work on the European market without MiCA license, and or if it is possible, which rules you have to follow. I'm going to give some examples, and then we're going to look for some jurisdictions which would be able to facilitate your mainland or for your business, from which you'll be able to enter the European market. And the first thing first, yeah.
Nikita, can I interrupt you? Sorry. Guys, into the chat or in the question section during the presentation, you can type your questions and we will be asking them in the end of this webinar and go through Q&A session and answer all your questions. So don't hesitate during the presentation to type your questions and we will answer them later. Thank you.
Thanks so much, Vadym. Yeah, please ask questions. Let's switch to the presentation. Now, as I said, first of all, we're going to start with a little bit of background on what MiCA says about the working for the European customer without being licensed in Europe. What it says initially. Is there any legal gaps or any exceptions for the rule, or is there any rule in place? Then I'm going to explain a little bit on solicitation. And this is, in plain words, is direct marketing of the client. And moving a little forward without the presentation, you will see that there are options how we can work with European customer with so-called principle of reverse solicitation. That's why we would need to know what is the solicitation means itself. I'm going to give you some examples, what they would not want to see from you, what they would like to accept. They will also going to talk about the types of services you can provide or you would not be able to provide to the same customer or solicited customer or all these type of things. Then, of course, we will look at what are the mechanisms for the authorities to detect solicitation, how they can check it. In that sense, it's very important not only to know the legal obligations you have to follow, but also how they can check the violation. And from that point of view, you will see that even though they might be very strict on paper, but they will not, at some point, they will not be able to check everything you're doing, basically. So standing from that point, we're going to look at some ways to overcome the situation at the moment. Then I'm going to talk a little bit on geo-blocking, because it's very important. Is there a rule for the no MiCA compliant service providers to set geo-blocking for the European customer or no? Because it is a very important question where it was mentioned. And then I will take a little bit on the notes, very important things before we go for the last two parts, which are more examples. I'll give you lots of examples on that, so you can take time, ask questions on the examples, and then we're gonna move to the alternative jurisdictions where you can set the business initially, and then start working with the European with these rules. We have to be very careful with the rules I'm explaining here. We are trying here just to scratch the surface. It doesn't mean that I'm giving you everything that is. It's not possible, obviously, but we need to just have a general understanding how it works in Europe right now. So here's the background. So there are few legal references to what I will be saying, but the general rule is that to be able to operate within the European Union, you would need to be European authorized company, right? The authorized service provider, or financial entities, such as credit institutions, so on and so forth. But the general rule, you're not able to provide services if you are if you didn't get the license. However, there is one exception, and there's only one. There is no more than one. So there's only one exception to this rule, which is Article 61.2, which says that the third-party firms, service providers, crypto businesses, could offer services to the local customers, which are residents of the European Union, without proper authorization, with the principle of reverse solicitation. And the first passage says that this is basically it. So with the so-called, when there is exclusive own initiative of the client to target your entity, your service, you can provide them with that service. If they found you on their own, if they were not exposed to any sort of marketing, and they just contacted you directly, this is only one exemption how you can work with European customer. And here is very important to mention that this regulation and the ESMA approach to the regulating things was very strict, in the sense that they so how do they check what is reverse solicitation, right? First, they need to determine what is solicitation, and everything out of scope of solicitation, if the client wasn't exposed to any sort of solicitation, then it would be reverse solicitation. And here you can see on the next slide, they did explicitly stated examples. What are so-called like solicitation methods the company could use to get the clients to their services. And solicitation is basically could be online advertisements, brochures, phone calls, pop-ups, banners, face-to-face meetings, press release, websites, messaging, invitations, and so on and so forth. You see, there is a very extensive list, literally covering almost everything. And and lots of people asked the regulator, why is it so strict? It's even more strict than the MiFID directive, and their principle of reverse solicitation. It's even more strict than that. And people were asking, why does it cover everything on paper? The answer was that basically the crypto is a high risk industry, and we want to the customer be protected from any unauthorized service providers, and also we don't want many people to be to get companies somewhere else and then get the European market using these principles. So we just want to make very narrow, as narrow as possible. However, later on you will see that even though they stated this is all prohibited, right? You cannot do direct apps messaging or invitations if you're not authorized in the European Union, or you cannot call people. But they will not be able to check many of those. They will be able to control and track the violation of some of them, but not any of those. Later on, I will discuss how it works and what you would be able to do
Can
with
I
them.
ask
Right?
you a question, Nikita,
For sure.
about
Yeah.
this previous slide? Yeah, but mentioned like website is accessible to EU users. So if I have a website where customer can just see, it's already a solicitation from this slide. Am I right?
It's not. So this is. I will get into details. So it could be yes or no answer. So
Okay.
depends on the circumstances. But like, and answering your question, if your website ends with a set of letters like FR or IT, which means Italian domain or French domain, this would be a violation. But if it's something neutral, this doesn't necessarily mean that there is a violation in place. But they explain it later on. I will also explain it to you. But yeah, it depends. That's why I mentioned some of them, even though they are very strict on this, they all mention this list. But we can work with that in a sense to be able to provide the services, right? So how it usually works, the principle is that when you found the client not using these services, so all of this you cannot use, and then you found the client and he contacted you on your own, you got the client with the principle of reverse solicitation, there are second barrier for you to operate the services with. You can actually, what you can do is you can provide the service that he have been asked you for, right? So if he asked you for the crypto exchange, you can provide the crypto exchange services, but you will not be able to provide. You will be able to provide to only the same type or similar type of services to the customer. In that said, for example, if the customer came to you with the principle of reverse solicitation and they required you for crypto exchange, you will not be able to provide him with the service of custody of custody, because it's essentially different type of service. And the principle says that you would need to, even though they contacted you for some part of services, you would be able to provide only this type of service. And examples here are that if you're issuing tokens, right, you can, the utility tokens, asset reference tokens, and e-money tokens are not the same type. So you cannot offer different type of assets from your portfolio. Also, different technologies. For example, storage and transfer. That's what I said. If you came for transferring funds or crypto, you cannot offer storage of funds unless the customer asks you directly, right? Then, if, for example, there is very high liquid assets or illiquid assets, crypto assets, also you cannot. They are not similar or same type. If the tokens are identifiable with identifiable offer and non-identifiable offer, these are also different types of providers. This all said, if you pass this second barrier, then you can provide the services to your customer. But there's also a third barrier, which is called time period barrier. I will talk about it a little bit later. You cannot provide even the same type of services, but for a year after the client contacted you. Let's say the client contacted you for sort of exchange, but then you finish he finished using your service. You cannot target him with a message like a year after the contact and say that hi, we got a new product launched. This would be considered the solicitation in the sense of MiCA. So there are three aspects, again, just to be very, if something is unclear, again, three aspects. First, you cannot use this direct marketing or solicitation methods. Then if you pass the first time and client still comes to you, you cannot offer him different type of services he asked you for. So transfer, you cannot offer storage or vice versa. And then you can offer only within the limited period of time, which I will talk about it later in the end of the presentation, which is also very important. Let's move a little bit towards examples. And Vadym, if you have any questions, please ask on behalf of our audience. It will be very useful. But the examples when you can basically interact, we don't call it solicitation, we don't call it marketing, but how you can interact with client without breaching the MiCA regulation. These are, first of all, it could be the educational materials, right? The materials which basically explain how general industry works or some topics, blockchain, what is what is DeFi or other set of topics you can use to educate sort of customer and do not fall within the requirements of the solicitation under MiCA. However, there are some rules which you have to follow while publishing and educating people on that sense. You shouldn't lead the audience to take action or visit your website. There shouldn't be any direct links to your website. In that sense, that the educational material published on the website shouldn't really should be connected directly to this website that is providing services. So even if you're providing sort of information or educational materials on your own website, this would be considered a violation, since you on the website you for sure have some links to your services, and this is in breach. You can if it's in person situation, if you're educating people in person, like conferences or sort of webinars, there shouldn't be any service brochures sent to you or distributed explaining how it works, how can you help them with service. Also, you shouldn't promote in any form and guide audience on how to join your server, how to join your website, how to log in, or how to complete the profile. These all type of things are excluded. But as for the rest, if you've been very, very careful in just sharing educational materials, this is not considered to be reverse solicitation and in breach of the MiCA requirements.
I have a question.
Yes.
Nikita. So I can't publish articles on my blog, on my website, which is like blog.myname.com, for example, with education materials, because it will be considered as a solicitation.
So again, coming back to the website, if this website, so how do they assess it, right? This is the question. To state and to make a verdict that you are in breach of the requirements, it's not only one specific indicator. It should be considered in general. And let's say if you have educational material on your website which has a link to your services, and the website ends with FR, which is France, or IT, so Italy, then considering all the factors around, this might be considered a reverse solicitation. However, if you just have um, random website with the .com ending and just having published educational materials, this would not be considered the reverse solicitation. And here is a very good question, because you can use this for, let's say, the new customers. They might be looking for some information, some explanations, some more knowledge, and being very careful with what you're offering, being very careful with your website and with your marketing, you potentially can lead the customers from the point A, which is educational materials, to the point B of your services on the website. However, again, has to be, this is something weak. You cannot state for sure this would be a violation or not, because it's some of factors, right?
I just want to understand. This is, for example, I am as a exchange owner outside the EU, have a natural website. I mean, not with .com, with IO, with something like that. And I just publish some, for example, English-based materials on this website without even knowledge about the MiCA itself. So in my country, it's not it's not my goal to attract new customers from EU. And in the same time, somebody from SEO, found this article and registered it. And this is not violation, because I am even not trying to somehow promote it directly to the customer from, let's say, France or Italy. Yes. So this is what I can do, whatever I want to
It
do.
is it
Right?
is very good note. It is very good note. I will also a little bit mention this in the geo blocking part of the presentation, because they considered the ESMA. They are not stupid, obviously. They considered this type of way of going with clients on their own, and they gave some recommendations. So yeah, essentially yes, of course you can do that, but there are some questions also on that note. Let's move to the next example. The influencers and third-party promoters. Very good topics to bring on the table. Can you hire an influencer? So the question is that usually, to promote your services, people use the influencers, right? And they give direct links to the website. They access promotions, promotional deals, incentives for the customers. They speak that how great the project is. This you usually pay these influencers directly or via the marketing agencies, and this basic answer is that it is a violation. It will be considered a solicitation in the sense of MiCA, because this is something you are not doing directly, but this is something that influencers do on your behalf with a contract in place. They are paid for it, and this is something that is considered to be a solicitation. But however, there are some exceptions to the rule. If the influencer presents the topic as a pure feedback on the service that they just come across randomly on the website, and they do not mention the direct link to the website, and they have no promotional deals, in theory, this is not considered as a reverse solicitation for or as a solicitation for the MiCA requirements. So in that sense, still think about how can you use influencers while targeting the European market. But you have to be very careful what they say. they have to present it as a pure feedback on the material they just came across randomly, and you have nothing to do with them in place. Also formal agreement or compensation is usually almost considered to be solicitation. So think about how can you work on this. But if you have no formal payment in place or contract in place, and if they're not displaying links to your website, and they do not have promotional deals, in theory you can use this influencers or third party promoters to your benefit.
Nikita, I have a question.
Questions?
My brain working in different direction. So I can hire several influencers and order this promotion of my competitor outside the EU, and like with all violation of solicitation, and ask to promote somebody outside in France, in Italy, and then just send the link to this video to regulator, and oh, they are violating our rules. Am I right?
So this is a very good question. Again, very good question. What happens? They will start, for sure. They will start. It is a huge red flag for them, as well as this. This is something that there are lots of red flags that they are checking, and if they see this information, of course they start the investigation. However, they will be digging into the background of the influencer. They would check whether you have formal agreements with them or not, on which behalf they are working, or who offer the services and this type of things. But I think in the end, it will be obvious that maybe the company was not on its own purchasing the service from the influencer, but it was made by third party somewhere in outside the European Union. However, the question is, let's say you are paying to the influencer, but from your unrelated entity, right? The entity which is owned by third party nominee or somewhere else, and then you pay from this entity to the influencers. Practically speaking, it will be very difficult for them to it will be very, very difficult for them to accuse you of violation of rules. Very difficult. But then they might request you for doing geo blocking, which I mentioned later on.
Mhm.
And if they see the huge stream of new customers coming from these type of things, and you have nothing to do with that, and you are not in violation of these requirements, they might ask you for something. But again, there are some things that they can do and things that they can check, and there are other things that they cannot check. And in that sense, we're going to explain it later. But yeah, this might work. I think it is one of ways of how to deal with it, honestly. Next, the question we also got many questions asked on that topic as well. What if you already have many clients working with you? If you already, before MiCA, you got lots of clients, businesses, customers, retail, which have been which you did provide your services in advance beforehand, before this all started. Can you continue working with them? Are there any rules how you should work with them, which services you have to offer and which services you shouldn't offer to them, and how it should look, right? The answer is very simple. So the answer is yes, you can work and continue working with the ongoing customers and clients that you have already in place. You can work with them. There is no problems. However, the exact same rule will apply. The same rules regarding the types of services you can offer them. You cannot offer them services of different type. Let's say if you will be working with them as for transfer or storage, you cannot offer them completely different service. And also you have to be very careful with timing. If you've been working with them 10 years later, 10 years ago, and now MiCA is in place, you will not be able to share the promotions or send the new information to them. Here on the slide, you can see that I mentioned the what is not allowed, and you can see that again this is different type of services which was it differs from originally requested, and also the certain amount of time which passed, and you cannot directly link to the customer or the original initiative, right? They so the question would be, your question might be that what does it mean time, and how long is and which period of time are we talking about, right? So they gave a very vague example, which you will see later in other examples, but they said that um, they mentioned 1 month as an example. If something service was offered, then the client didn't contact you since then, and then 1 month after, you offered him or her different services. um, this is mentioned as a Q&A session, so it doesn't really have very much of binding effect to the every situation in place. But this is what they said. Um, Originally, yeah, we have to be careful with the timing. Again, 1 month for some, it all depends on the service, right? Some services might never expire if you offer them custody and they keep the custody, right, for forever, basically. This countdown timer never starts. But if you just initiated the transfer of cryptos once, and then you're trying to offer them something else, or even same time after a long period of time, this might raise some questions.
I have a question. I believe we all thinking about the biggest player like Binance, who was actively working on European Union market and right now doesn't have any license, as I believe from the list. So they have huge base of the clients in Europe, and I believe they continue providing services and will continue. So this is the question: will it be some, from your point of view, like lawsuit or some like questions to Binance regarding solicitation with the existing ongoing client relationship?
Yeah, so they really got a very huge client base at the moment, and lots of them from the European Union. I do agree they don't have any licensing, and I believe if let's say we got the latest transitional period is like 18 months, which is summer July 2026. For till the time, I'm very certain they will obtain any license, at least one license in a jurisdiction. They for sure will get. I don't think they will just try to leave the European market. Is too big, and the customer is too. There are lots of people are using Binance at the moment. However, if they didn't manage to do so in 1 year from now, let's say roughly, of course they will be. As they're the biggest trading platform in the world, there will be huge attention towards them from the regulators, not only from the local regulators but also from the European regulators, and there will be some restrictions in place. They will impose some issues. I do think that they will just ask for the. By the way, the violation can lead into fines, and the fines are huge. They up to 5 million euros or 5% of your annual turnover, which is a huge number for the Binance, I believe. And I think they will be very likely exposed to these fines if they do not manage to work. So I believe 1 month after this period ends, they will be able to send some promotions to the clients because the 1 month they mentioned. But then 1 month after, the time period ended, and then that's done. They cannot move forward unless the customer reapplies for the reapplies everything again. Let's say if they keep in their custody, right? Custody of the wallets, that means that this time period never ends. But they will be able to only offer custody in future, so they will not be able to provide trading, right? That's basically how it works.
Because
Again,
they usually promote new products. So, I mean, we launch a new token on the platform or some, I don't know, yield or some stake something, receive something. So this is new, I believe. It's not like a service they provided before. They are trying to promote something like involvement. Yeah, so you should
Of course,
do some
they do
action on
placing.
the
Yeah,
site.
they promote tokens all the time. Placing is another type of crypto assets, crypto service, right? They do all the time promotion of trading, right? And NFTs and these type of things. This will be restricted, of course. This will be restricted. Um, let's move to the next one. I believe we have many things left. Interesting. This is actually, I believe this is one of the most important parts of the presentation, because no matter what is written on paper, but what is more important is how they detect the violation, and if they don't have, I mean, regulator doesn't have much of effective mechanisms in place regarding the tracking the violation, everything I said before doesn't make sense because they will not be able to catch you, right? Uh, and they have essentially, there is Article 96 of the MiCA regulation, which explains all the list of the actions the regulator can do. But the most important are these three that I mentioned here, and they're also mentioned in the guidelines with examples. So examples I took not from my head, but from the guidelines they said they issued. And the first thing they can do is they can so-called checking. Um, they can check the contact details. Contact details means the website URL, the phone number, not like the phone number, codes, and these all type of things. So, in theory, as I mentioned before, if your website ends with LU, which is Luxembourg, or DE or FR or IT or LT, something which is from the European Union, this is a huge red flag for them. This is a huge explanation of the target. So that's how they basically will monitor. They have tools to see which are website from which jurisdiction. They will use these tools, and in very simple few ways they will detect whether your website is on this domain, which is European domain, or not. Also, if you're using the phone numbers which start with the phone's codes of the particular jurisdiction, especially European jurisdiction, like 39, which is Italy, or 33, which is French, or others, right? This is, friends, these are also the clear indicators that you are trying to solicit and target the client. This is a huge red flag for them. We better try to avoid these red flags that they are scanning for. They are like bulls looking for the something to catch on. The second thing they could do is so they mentioned it. They said that it's called customer surveys. So basically, this is the most I wouldn't say the most effective, but it's the most widespread method that they can use. They just will do a survey. They will ask retail customers on the street. They will ask people online to ask which platform they are using for now. And if they, let's say, how it's supposed to work, if they ask a customer, and like many customers, which platform they use, and they all point towards you and they say this guy is providing the service for us, then they will take it the initial look at the company, right? They will take I believe in each country has the Ministry of Statistics or something. They will have a clear statistic of which provider which customer uses. Then they will try to detect the main players, see their websites, and if they will try to find these red flags in the point A, the first point, and see whether they have anything to do with. Otherwise, it will only only finishes at the level of the statistics. If let's say if like 1 million of customers are using your service, 1 million, and then they all point directly towards your website, this might raise lots of questions. Yes, but if it's not much, I believe there should be any problems with that. And the last one they can use is called marketing and social media monitoring. Basically, which said that they also have tools, as I said, to track online marketing activities. They also have they can track the social media activity and the social media statistics. They have they can see if you're targeting they do have access to the biggest platforms like Google. They can see that who is targeting European market and or particular market at the moment. They can request that information, and they will be able to, again, if they find you, you using direct targeting marketing on that market, they will ask questions or start initial review of your website or looking for another red flags that might be in place, right? So these are free. Basically, guys, this is it. Nothing else they will be able to use. This is free. And as I said, coming back to the first part, even though they mentioned lots of different, so for example, how can they track the face-to-face meetings, right? It's not possible for them to track, only using the surveys from their clients. Or but if they B2B segment, this will be very unlikely that they will just participate in this service or so on and so forth. They can track actually phone calls if it is from the code phone codes using the first method. But again, the phone call is something very unlikely they will be able to track. Events also something that for them would be very, very difficult to track any events in place unless it is explicitly marketed everywhere and they just will come across randomly the event. But many things that unless you're using the URL which ends with the local European country, or you're not using targeting ads, this they can track, of course. You'll be fine with most of these things if with the right legal approach and support on that note. If it makes sense.
Yeah, Nikita. Just to want to mention that we on time right now. It's 46 minutes already left, and we have time limit for the webinar. So let's focus on the main things. And in case like more information, I believe, can be shared. And in the chat, our helpers will share links to consultation with you and with me for additional questions.
Yeah, no worries.
Let's
Thanks.
move.
Yeah, my bad. Again, we have 34 slides. Right.
Yes.
Let's go next. Geo blocking. They mentioned that so there is, again, this is a Q&A session. They said that if something unintentionally solicits clients, and that's thing that you mentioned before, then in that sense, after they might recommend you to use geo blocks, but it's not an obligation, and this is not something that you should implement and that you have obligation to implement after the MiCA enforce. So no worries about geo blocking. Answering that question. Then also there are a few important notes that I would like to mention again. If you are an authorized business under MiCA requirements, and then you're asking outside the MiCA company to provide you with liquidity, or to let's say you're working with a company in El Salvador or in Argentina for the liquidity, right? And you're asking for the any type of other services. This, even though you contacted them directly, this might be in breach of the application in MiCA on their side. So they might be seen as providing the services to you, even though you're an ongoing client. But this is business to business. This might be seen as solicitation outside the European Union. Again, this is a Q&A session. This is not something legally binding, but this they gave it as an example, and I have to tell you that. And also, you cannot redirect clients. Again, even if you're MiCA approved company, or let's say how it should work, you partner with someone who get the license, but then they just redirect clients to you. This doesn't work like a solicitation. This doesn't work as under this principle. So you should be very careful. Again, the timing, as I said, the timing is very important. Then here is this example, right? With 1 month somewhere, it should be here. Or no, but yeah, the relationship that you have should attribute to the specific initial so-called idea or initial request from the client, and you cannot give them something that they never ask you for, right? unless it is the same type, but it should be within the reasonable timing. I believe you'll be able to see this after the webinar. So I'm going to skip most of the examples. Again, here this is the full list of examples. Here I give lots of details which would be considered, and which particular cases would be considered solicitation and which wouldn't be considered. So just I'm going to skip on that note and go to the places where we can move to, because look, basically what I'm trying to say that there are lots of alternatives if you are following the rules that I mentioned before, all of these procedures and all of these ideas that I said before. But I just scratched the surface. There are many more inside, but main thing was that having a company or crypto license in one of these jurisdictions or any other would allow you to work with the European market. And this here I indicated let's say 8 more popular, but there, of course, there are much more of them. These 8 we do recommend going with, which are in particular Argentina, Bosnia and Herzegovina, El Salvador, Canada, Seychelles, South Africa, Singapore, Australia, and there actually are many others, but these are good to go. I believe on the previous webinar you mentioned El Salvador, so I'm not going to mention this jurisdiction. However, it is quite good for the customer. We were going to go with the following 3. First one would be the Bosnia and Herzegovina. Very good jurisdiction for these all type of activities that you might think of. I'm just going to quickly mention the requirements, because this is the country, this is the region which is within the European continent, right? But it's not the part of European Union, which basically said that the MiCA requirements does not apply to this particular jurisdiction, and the licensing is very straightforward, quite similar, and similar and swift and fast and simple compared to the huge markets and crypto regulation, right? The requirements would be very simple. You have to have one director, which would be able to visit Bosnia and Herzegovina for a few days for the registration and for the notary signature. So you cannot do it remotely. There's minimum share capital of like very minimum share capital, which is 1,000 BAM. Then again, this is you would need to open the local bank account in Bosnia and Herzegovina to maintain this share capital. Also, you would need to share the requirements of the MO officer, because the MO officer has to know the local language and has to know the local legislation and these all type of things. And the last part is that you don't need to have a local office there. Virtual office would be enough for you to start. So basically, what you would do within the 5-6 months, or even less than that, if we're lucky, you just come as a director, sign all the documents. We're gonna establish your company. You're gonna pay the minimum share capital. No office needed. No local employees needed. Comparing to MiCA requirements, which you need to have board of directors in country of registration, and you're ready to go and you start. The thing is that this is the list of services you can provide. You can provide custody. You can provide crypto exchange for crypto to crypto. You can provide crypto to fiat, trading platform transfers, and also sort of offers be an issuer of and sale of the virtual currency, right? Very good option, very straightforward, and using the rules that I mentioned before could be a great place to go with. The second one, Argentina, guys. Argentina is very nice place to go with. The thing is that Argentina currently has very minimal requirements and gives you a huge access not only to the whole LATAM market, because Argentina is the biggest country one of the biggest countries in the LATAM, right? They speak Spanish. They have trade agreements with all the LATAM countries, almost all of them. So with Brazil, you can go over there, and also, but also you can, with right approach, you can go with Europe, and that's what are the requirements. First of all, no criminal records for the shareholders and founders. Also, as I should mention before, here you also shouldn't be any exposed criminal records, and any political exposed person This is the directors and shareholders has to be clean. One director should be in place, but there is no need to visit it in person. No requirement for local director. Also, there are two officers, ML officers. First one, compliance officer and alternative compliance officers. They has to be locals. So they have to be locals and they have to have appropriate education. And there's also the minimum share capital requirement of 6,000 USDs. However, there is no requirements for the physical office. Again, everything could be done virtually. Everything could be done remotely. You don't need to come to Salvador, to Argentina, and it will be done in, again, 5, 6, or even 4 months if you're lucky enough to get with all the notary deeds and so on and so forth. Next one, and the functionality is actually quite wide. Just forgot to mention, but you can go exchanges, custody, transfers, issuing of tokens, also stable coins. So Argentina is good for usually for token stable coins as well, but also for transfers and exchanges. And the last one here mentioned, but not last one in the list. But again, South Africa, again, very good option. No local shareholders or no local directors are needed. There is only one person that has to be local, is local key individual, the person who has a qualification, sort of experience, operational ability, and is registered with the financial service, with the register of financial service providers. So it's main person, and there's which is intermediary between the regulator and you, and the local compliance officer also is required. So 2 people has to be in place in South Africa. And that's basically it. Virtual office is enough, and share capital, there's no minimum share capital in place. Again, you can go with whenever sum you need. The only thing is that usually they would ask you to show them sort of financial stability to run the business, to get the license, but there's not something fixed. You go with which number you want. And again, the virtual no share capital, that's what everything I mentioned. And the functionality is, again, quite wide. So crypto exchange, custody, advising, token issuance. This is within the Financial Advisory and Bidra Act from 2002. Guys, that's it. I'm very open to your questions. Vadym, if you have any questions, or you can continue, please, floor is yours.
Yeah, thank you. So we have a couple of questions. I believe we can answer them right now. And also I want to add from my side on solicitation on Paris blockchain. We visited like 3 years in a row, and the year before it was a lot of centralized exchanges. And this year is only a couple of them. And for example, Bybit doesn't have any license in Europe, and they presented product Bybit wallet. So is it like allowed to do almost the same naming, but for decentralized product, for example, to offer on the exchange, on the exhibition? And they never mentioned like on the information that Bybit exchange itself, but this is another product which is with the same name, but Bybit wallet, for example.
Again, very nice question. So we know that fully decentralized, so the wallet, even if you're providing non-custodian servicing, which is like creating crypto wallets in a non-custodial way, so you're not keeping the thing, or you're fully decentralized exchange, right? You're fully decentralized. You have nothing. There is no central operation. These are the services which are exempt, or like DEXs are exempt from the MiCA requirements, because if they're fully decentralized, you would not need to get the license. But if you have a little bit of touch on that, if you provide custody for the clients in that sense, even on the blockchain, you would still need to get license. And this is a very tricky question. Right now, I think they're fine because the transitional periods are not ended up yet, and I think they can somehow manage it. But in the end, they would need to get the license, or try to ask all of the customers to have the wallets, and then work from the principle of ongoing customer, work with the customers with ongoing, which they have established their cooperation before the MiCA.
Okay. Another question from the chat. a company with the WASP license did not receive CASP yet, and if the client base is the same as before, can company continue to operate without CASP license? Am I right that till the next year, depending on the country, you can continue operating as a WASP as previously, and this is not this rules not applying to you yet?
So as I understood, can you go if it so after the transitional period ends? Usually you're gonna lose the WASP license. You're just gonna convert to the normal company, right? Basically, you'll be excluded from the registry. In some countries, registry will be totally eliminated or it will be deactivated. So you gonna lose your ability to provide the services. However, if you would like to try with using this principle of reverse solicitation and to apply for the local users, you will be in breach of the registration because you are not third country provider. So if using the reverse solicitation principle allowed only for the customer or for the companies which are based outside the European Union. They could have license, they couldn't have license, but they should be based outside the European Union. But if you're already based within the European Union, you would need to get the license to be able to continue providing your services. This everything I mentioned with ongoing clients or with new clients with the reverse solicitation does not apply if you are based inside the European Union.
Okay. I believe we are already out of the time, and I want to thank you, Nikita. Once again, our contacts and presentation will be shared to the all registered participants and people inside the webinar. And you always can contact us with Nikita over the link provided inside the chat or inside the presentation. So have a good day. Thank you for visiting me.
Thanks, guys. You're free to ask any questions in the privates. I'll answer it, whichever questions you have. And thanks for your participation. I believe it was very useful for everyone. And I believe have a great day.
Yeah, bye.
Okay.